SJC-12397, G4S Technology, LLC, v. Mass Technology Park Portal.
All right, Mr. Welch, you may proceed.
Good morning. My name is Christopher Weld. I represent the plaintiff appellant G4S Technologies, LLC. This case presents the court with an interesting issue. Whether to return to the current common law, to retain the current common law rule in construction contract cases that bases recovery on whether the contract was fully performed, and if the contract was not fully performed or strictly performed, then defaults the quantum merit rule, which requires good faith unless the breach is de minimis. So in the case of an intentional breach or a bad faith breach, the cases use both terms, the claimant is out. There is no recovery, regardless of the circumstances.
Put aside all the, what seemed like factual back and forth in the briefs about the nature of the compliance and whether it's $4 million, $14 million, all those issues. Why is it a good idea in the context of construction cases to say, well, if a general contractor deviates from the contract and it's clear they know they are, that they can still recover in under the contract or perhaps even just in equity for quantum merit?
The primary reason why it's a good idea is because the current structure is punitive. That's not the purpose of our civil system. The civil system is designed to be compensatory. It's a benefit of the bargain, a harm-damage analysis, it's a value exchange. Whereas there are other structures in the public contracting field and even in the private contracting field that adequately deter and protect the public authorities. That's not the role of the contract quantum merit structure. For example, let's look at the deterrent issues that are raised by the Attorney General and his amicus, as well as the other side. If we look at a public contract, the most powerful remedy is debarment. Now, most of the...
I'm sorry to interrupt, but all of these three things that you're going to go through, the possible indictments, all 93A, they didn't exist in 1906 when Sipley was decided by the Supreme Judicial Court. So I just want to sort of save you time from going through the litany.
But that's precisely the reason to change the rule, because perhaps 100 years ago, the deterrent effect was necessary. In this environment, in a highly regulated, particularly in public contracting, you've got debarment, false claims, et cetera, et cetera. I won't go through them unless it's helpful. But the point is, the landscape is different. The contract in this case is 1,400 pages. And the rule is, absent strict compliance that is not trifling, the contractor's out. It's a default, it's a forfeiture, it's a penalty.
Well, how come so many states haven't adopted the restatement 241 then?
Well, it's tricky because if you read, I submit to the court that in fact the majority of the states have adopted the restatement, the majority that have considered it. And in addition, in a quantum merit context, because these two rules fit together. And in a quantum merit context, you've got, again, you're double counting in the case of an intentional breach or a bad faith breach. You're saying you're out on contract because you lack strict compliance. Then you're saying you're out on quantum merit because you didn't perform in good faith. You're left with nothing. The purpose of the quantum merit remedy is not to judge, not to make value judgments from the sense of intentional versus unintentional. It is to adjust.
And I get that part of it. Can you explain to me how your rule works in terms of adjustment? Because your client clearly, intentionally breached the contract. So I'm trying to understand how the rule you're formulating is nuanced and will, reflect a proper calculation of what you should get or what you shouldn't get. Because I get your point that the other rule is all or nothing, and that seems like they're getting a windfall. But how does your rule work? Will it provide necessary adjustments to penalize your client for not doing what they're supposed to do?
Yes.
And how will it work, and how would it work in this case?
Okay. So if you look at the materiality analysis,
Right.
you would go through first of all, it's an uncured material breach. So the first point we get to is, was there a cure? And there certainly was a cure with regard to subcontractors getting paid, because by the final pay requisition, each and every subcontractor was paid, each and every vendor was paid. That is undisputed.
I get that, although having spent a lot of time doing these kinds of public construction projects, when subs don't get paid, there are all kinds of little problems along the way. They don't get paid for a long time, the work isn't always up to snuff and everything else. But so, again, how are you going to get penalized? Because I don't like the idea that your client intentionally breaches on a public contract and there's no remedy. So what is the remedy here? What's the proper remedy?
Well, I respectfully submit that in a contract analysis, and certainly in a quantum merit analysis, using the concept of penalty is disjointed. The penalty comes in with the other built-in remedies in the public contracting sphere.
Well, you say that, but first-year contract says that quantum merit is a remedy in equity, and one must come in equity with clean hands.
That is true, except the presumption of equity in this case is that you're already out for some reason on contract. For example, an illegal contract. So you're now double counting the supposed bad behavior that excluded you in contract. And if you look at the cases, there are a couple of very illustrative Connecticut cases, Vicenzi and I think it's Dubalo.
But you only get to quantum merit when there has been a breach of the contract or there has been no contract. I mean, so you say double counting, but the reason you're in quantum merit world is because there's been a breach.
Precisely.
But you can have a breach of contract without there being unclean hands. Not every breach of a contract is intentional.
But in this sphere, every intentional breach, if you use Sipley and Andre, every intentional breach, the intentionality of it is counted twice. You're out on contract and you're out in quantum merit.
Other than the fact that that is negative for your client, what's wrong with that?
What's wrong with that is
That behavior being counted twice.
it's unjust, and it's contrary to what the intention of the civil system is, which is compensatory, not punitive. So the quantum merit remedy, if that's where you end up in this analysis, is to look at what the value exchange is. It's not a free pass to the contractor. It just says you have to prove what value you added, minus what you were paid, minus what damage you caused.
Isn't that the answer to Justice Kafka's question? So there's no potential windfall forfeiture, and you just answered Justice Kafka's question is what happens.
That's what happens in the quantum merit. If you drop down to quantum merit and you say let's say there's an uncured material breach under the first uncured, second material with the 5 factors. If neither of those are the case, we're still in a contract remedy, and we probably end up at the same place, because ultimately we'd end up where we started this case. This case started as a...
I don't get that. I'd like to understand that, because I'd like to have a rule that is not an all-or-nothing rule under the contract theory, but I don't know how it works. So how does it... So you've got a intentional breach that you've cured I guess, as you're saying. You've cured the intentional breach, but and so there's not a material deficiency or somehow. Do you get your full contract remedy then? So that you basically were allowed to intentionally mislead a public entity and get your full recovery? I'm just trying to understand, because again, as the chief points out, quantum merit, we're looking at equitable issues. But I don't know, are there any quantum merit cases where you get equity when you've intentionally breached something? I'm just trying to find, is there some middle ground here?
I think I've got two questions.
Go ahead.
The first one is, what happens at the end? So let's say you decide that the breach has been cured.
Right.
If there is any damage from that breach, even though it's cured, the damage will be factored into the contract recovery analysis, the same as in every other contract case.
And is there a good case that does that? One of these cases you're saying that adopts the restatement, does it penalize? Is there a good example of how you penalize someone applying this restatement 237-241 approach? Or is it, again, all or nothing, you get all and they get nothing, or they get all and you get nothing?
No, I would suggest I don't think there's a case that specific that I could cite you. Mm-hmm. But I think when you apply these factors, what you're really determining is what's the vehicle for recovery. So let's go back. The case started with claims about liquidated damages, delay in delivery, right, and defects to the work, even though there's a certificate of final completion accepting the construction. So if this case were to play out under the restatement rule, there would be an analysis of what damage did those, first, were there breaches or were there...
So there are breaches. So we know there are breaches, and we know that you intentionally lied on the representation. So we know there's some breaches here. I mean, that's an uphill battle for you, isn't it?
Yes.
So there are breaches, but there's also sign off on the ultimate project. So we've got intentional misconduct, and how do we value those? Does the restatement tell us how to value those?
Yes, there are 5 factors.
Well, I understand how they determine whether something is a material breach, right? But is there any discussion of damages there? Because I don't like the idea that you're getting everything also.
I would suggest, I think, perhaps I'm not being clear. I think what would happen is if you say there's no material breach, it doesn't mean there's not a breach. Mm-hmm. So there is an ability to recover damages by the authority. And in fact, the authority brought a counterclaim here and has alleged that it is out $1.6 million on the value of money that they otherwise wouldn't have paid out. We disagree with that value.
So there's a damages for immaterial breach under the restatement approach, including potentially the loss of value, meaning that they paid out when you hadn't actually paid the subs. So
there's actually damage for an immaterial breach, because if there's a material breach...
Is there any discussion in the restatement of how you calculate damages for these types of breaches?
No, not the type of conduct that we're talking about here. And I think the Commonwealth, or the authority, has proffered a theory of time value of money, which can be monetized. We disagree over how long things were late for, what the right interest rate would be to be applied, et cetera, and we believe our analysis suggests that the value of this breach is de minimis, and that the court should have so found $1,700. The Commonwealth's theory claims $1.6 million. But regardless, there is a remedy for that breach, and it can be had in the context of a contract analysis. It certainly can be done in the quantum merit analysis, provided that one is not totally prevented from recovery by the intentional acts.
Let's assume for a moment that this were not a construction contract.
I'm sorry, Your Honor?
Let's assume for a moment that this were not a construction contract, which I know it is. Let's
Yes.
assume we're in the regular realm of contract law. My understanding, when Mr. Williston and I were classmates, is that a material breach by one party releases the other party from its obligation to fulfill the contract, correct?
As black letter law, yes.
Okay, so, and your argument here is that in the construction world, something less than a material breach may be sufficient to release the other party from its obligations.
I would suggest to you that the ruling in the Superior Court, as well as some of the case law, is absolutely strict compliance,
Okay,
not
so
material.
let's assume we're not there. And your argument is that what you did was not an intentional lying with regard to certification, causing them to pay you when they should not have had any obligation to pay you because it was part of the contract that you were to treat your subcontractors appropriately, that was not a material breach?
I would suggest, Your Honor, that determining whether it's material, you would go through the 5 restatement factors. And yes, I would suggest under these facts, it is not a material breach. And in fact, the certified power case, which is a Superior Court case, explicitly found that on virtually the same facts, false certifications, and found that it was not a material breach because it didn't go to the essence of the contract, and it applied the 5 factors of materiality.
So if you're not in a construction world and you're in regular contract world, your argument is this would be found to be a non-material breach. It would not release them from their obligation to pay you under the contract for substantial performance, but they would get whatever damages they could obtain for your immaterial breach. That's
Correct.
And so, if you're right, then you need us to find that the breach was not material, because otherwise you're in the same boat as you are now, correct?
Except that part of what we're advocating on appeal is that the quantum merit rule needs to be brought into line with the rest of contracting world.
Okay, but in the rest of the contracting world, where there is a material breach that releases the other party from its obligation under the contract, then you would go to quantum merit, and I believe the black letter law is that you must show both substantial performance and good faith.
Well, actually, Your Honor, I would not agree with that. In non-construction cases, there are a number of cases that allow recovery in quantum merit where there is an intentional breach. The Herlihy versus Cushman and Wakefield, Meehan versus Shaughnessy.
An intentional, is this a construction contract?
No,
or
this
not?
is a non-construction.
Okay, an intentional breach that was viewed as a material breach.
Yes, such that
But
one
you're
could not recover in contract, and then there was a quantum merit analysis.
So you're saying that the doctrine of you must come to equity with clean hands has some exception, and what's the exception?
The exception is that you start from the point of view that there's been a breach. It's circular if you say
There has been a breach. You don't get to quantum merit unless there's been a breach, so.
that's my point. So if you count the breach twice, you've defeated the whole point of having quantum merit. It's an alternative remedy. So what you're really looking at is in quantum merit is, was one party unjustly enriched or not? And that's what the cases talk about. And so when you have something like the Meehan-Boyle case, in which they say, look, you breached the partnership agreement, you breached your fiduciary duty, you did it intentionally, but I'm going to allow you to recover for other things, other value you delivered under that contract. The only thing you'll be prevented from recovering on is the value that flows from the particular breach, not from the entire contract.
Okay, but then you get into the difficulty that Justice Kafka appears to be asking you about, which is that quantum merit is an equitable remedy, and the fact of the matter is, you guys don't look so good in equity, given the fact that you affirmatively lied time and time and time again and screwed your contracts, your subs in doing so. That does not make you that attractive and equitable party. So how do we get to where Justice Kafka is talking about that says you're appropriately sanctioned for your dirty deeds in equity, assuming that you're not going to be barred entirely from equity?
Because you're going to pay for the result of your dirty deeds in the process of the equitable determination of whether any value exchange is owed. In other words, you're going to have what value did you render, what harm did you cause, and what have you been paid? And if those things are upside down, one way or the other, then one party pays the other.
Aren't you saying this? You got to look at the project as a whole. It's a huge project in Western Mass, and you're talking about potentially $14 million. And basically, the way you're looking at it is the contract was delivered. And so then you get into a portion of it that's very serious, where there is a delay in payment so that your client's books look better, and that when you look at that, that you come with unclean hands and you have to pay at a minimum what those damages are.
Correct. And I think that's very consistent with these non-construction cases that I just cited, the Meehan case, the Hurley case.
Can I just ask, if we rule the way you want us to, how do you keep a party from just breaching a contract and the provisions that they don't care to adhere to? I understand you're saying in the end, everybody will get paid what they're owed. But how do we avoid having something like this happen again if we rule your way?
I think that there are both damages, and it costs a lot more money to fix something that's been put in a permanent structure than it does to do right the first time. For a pipe, you put a pipe in and you intentionally put in the wrong kind of pipe.
But it worked out best for your client to delay the payments to the subcontractors, right? I mean, you did that for a reason. It's not about putting a pipe in, it's about, sort of
Well,
shortchanging.
Let's go to our facts.
Yep.
So we would have to pay the damages that result from the delayed payments. We would be subject to False Claims Act exposure, potentially debarment exposure. All of the things that, for example, the Attorney General goes through, the DBE, what if you breach that? That has statutory penalties in it. You can be debarred, false claims problems, et cetera. So there is a whole, you have to look at this, particularly in public contracting, you have to look at it as an entire structure. There are other elements that the legislature have put in play that say, this is how you're going to be punished. But you're not going to be punished you shouldn't be punished in a civil case, because that's not the purpose of the civil system. It's compensatory. All these other things are layered on so that they're a deterrent to not do bad things. And for example, in the private contracting sector, you have 93A. Now, the legislature has decided 93A shouldn't apply in these instances. But instead, it has a myriad of other remedies that are deterrent to bad behavior. The civil system isn't intended to be that.
Doesn't this effectively, you're saying that we should amend, or perhaps we already have amended the rule that says you don't come to equity with unclean hands? Your view is that that's a moral quality. It's not a compensatory. It says we're not even going to give you quantum merit, even though there may be value given to the other side if you come with unclean hands. It sounds as if you're essentially asking us to change that principle, which maybe we should, but...
In this context, where there is this exchange of value that is uneven in certain cases, then yes, I think that the proper way to look at this, the fair way, the just way to look at this in a compensatory system is to say, did somebody get something for nothing?
But I just looked at Meehan. Meehan is not a quantum merit case. It's not analyzed that way. It's basically a fiduciary duty, and so is the case Meehan cites. And then Hurley is a 128. So you're really asking us to change the rules of quantum merit, just the way the chief said, because we don't have any support for this, right? There's no case that doesn't require you to come with clean hands and get quantum merit recovery, is there?
There's a Connecticut case, but I don't think there's no Massachusetts, I agree with you, that, although the Herlihy case,
That's a 128.
I understand, but it is a quantum merit case, and it does allow quantum merit recovery where there is a finding of misconduct.
Okay.
So I think that's the closest thing I recognize. It's a 128 case.
All right, thank you.
Thank you.
Mr. Kaler, good morning.
Good morning. May it please the court. My name is Robert Kaler. I'm counsel for the defendant appellee, Massachusetts Technology Park Corporation, which we refer to as MassTech. When G4S entered into its contract with MassTech in 2011, it agreed to the application of the rule of law that it now challenges. On page 124 of the appendix, the choice of law provision appears that the law of the place of the project would govern. References to Massachusetts law appear throughout the contract, not this specific rule, but this specific rule has been such a core part of Massachusetts law, including in the construction area, that it's been recited in Massachusetts practice for the last 25 years. Counsel for G4, there was a bid protest on this contract. I represented MassTech in connection with the bid protest. G4S's co-counsel on this appeal also appeared and was advising G4S at the time of the contract. And by coincidence, G4S's co-counsel on this appeal and at that time was counsel for DiMatteo 17 years ago when DiMatteo was enforcing this rule against a subcontractor in the DiMatteo case that's cited in the Contractor Association's amicus brief. They cite one case that says this rule...
Interesting, but legally irrelevant, so...
Correct, only to the point that they knew. Everybody knew the rule, and that's my only point. With respect to DiMatteo, I'll pause to distinguish it because...
I wouldn't spend a lot of time on DiMatteo. Your client is not the victim here. I understand if the subs were upset. I mean, they should be ripping mad. And I understand your client has lost the time value of money. And that may be meaningful, but I don't understand why we apply a rule that basically gives you some huge windfall when you're not victimized by this except for in the time value of money.
There are many provisions in contracts in which the contracting party makes the interests of others its own. Mm-hmm. If I hire someone to do the kitchen, but I say, employ my brother as an electrician, that's really why I'm doing it. I don't need a new kitchen. I want my brother employed. That provision's entitled to be enforced. So the argument is, in particularly on public contracts, many provisions are intended to benefit people that aren't, strictly speaking, the responsibility of the awarding authority, but the awarding authority, as a matter of public policy, has said, thou shalt employ minorities, women-owned businesses, comply with certain wage statutes. So therein lies, I think, the answer. There are those provisions, particularly in public contracts, the quantification of damages for which is very difficult. I'm sorry, Your Honor.
No, I'm just trying to, so you have an intentional breach. You can have different kinds of intentional breaches here. And then so they put in the wrong piping. Just let's use that example. They just decided, I know I'm supposed to do this piping, but I'm going to use this piping. And they do that intentionally, and then because you're a slow payer, millions of dollars go by, and you don't pay them, and then you say, gotcha. Does that make sense that we're going to, I mean, it's great for the state, we get a free building, but is that really a sensible rule?
Well, that's the Reading pipe case. That's Justice Cardozo's seminal decision in New York where the wrong pipe was put in, and it was his admonition at the time that, of course, the installation of the pipe can't have been done intentionally, so that's the doctrine in New York.
And in that case, they got nothing? As much as I admire Justice Cardozo, I haven't gone back to read the 1920 case or whatever it is, 1910 case.
They did recover. Mm-hmm. In fact, that was the rule in which that's why we cited it in our brief, and there were so many cases cited. But it was one that for us was important because Justice Cardozo, for the first time, said you can recover for substantial performance in New York.
Okay, can I then, so the restatement, which tends to care a lot about Justice Cardozo, why are they changing the rule?
Well, they're not changing the rule in the sense that they're not abolishing the rule that Massachusetts law has. They added into the definition of materiality a factor that some academics have criticized, which is good faith. The idea that whether or not a breach goes to the heart of a contract is really influenced by good faith or not is an open question. The Chicago School of you have a right to breach a contract, perhaps creeping into the restatement to the point where maybe we should allow people to intentionally breach.
But back to the way the chief framed it earlier, though, you've got a breach here that's intentional. Under our rule, it's always material, right? Every breach that's intentional is material.
Not exactly.
Okay.
Because you're in the realm of equity. Properly understood from our standpoint, this rule, which has 3 parts, basically says you have to comply with 100% of your contract terms. All the provisions, like the ones Justice Budd pointed out, don't always, aren't easy to enforce or quantify. How do you enforce them otherwise? But you can buy an insurance policy, and it's no cost as a contractor. If you perform in good faith, we tell our children, good faith, doing your best counts for a lot, both in life and in the law. And in this realm, what it says is, if a contractor simply does their best to comply with all the provisions in a contract, they insure against the risk that they won't be able to succeed and perform them all. And if they don't succeed and perform them all, they're insured that they will receive the fair value of the work they did do, so long as it's substantial performance, because a contract is not an invitation to do half the contract and then recover in quantum merit. So the rule essentially says, do your best, contractors, and if you can't fully perform, you get to recover. However, if you intentionally and in bad faith breach, without absent extenuating circumstances, and it's not de minimis, you have no insurance. Now, that doesn't mean you're going to suffer a loss. You may well complete the project and nobody ever knows that you breached. You may complete the project and they only find out at the end after they've paid you. Then you don't suffer a loss. They may, by fortuitous circumstances for them, perhaps, or bad circumstances for you.
You couldn't sue? You couldn't sue to get your money back in that context?
Well,
Because I would assume if you have an intentional breach and you discover it and you're entitled, they're not entitled to any money. Couldn't you sue for everything? Couldn't you sue for the whole 42 million?
There isn't a vehicle under existing law. Let me put it this way. There's no precedent under existing law for someone to have
But the
done that.
principle you're saying, it's all or nothing, right? So why aren't you suing them for all 42 million then?
Because there's no precedent for doing that in law. The issue is
So what we're doing is we've got a rule that says you get to keep what you've got, but you don't get any more, and you can't get it back. I mean,
It's a rule, like so many other civil rules, that in extreme cases has consequences that seem odd. If you don't pay $20 for an insurance policy, you could suffer a $100,000 loss or nothing at all. You could be insured against someone suing you or not. In this case, we made some judgments. I accept that. I made the judgment not to sue them for the money that had already been paid. They were paid 88% of the contract price. And, okay, the retainage was withheld after a 3-month investigation that I did, because I don't like to withhold money. They were a year and a half late, and there were defective work, so we withheld the retainage. We didn't know anything about this problem. Now, we connect it to what happened, but when we discovered it...
When you say we connect it to what happened, how are you, I mean, I understand the subs, they should be outraged, but I don't, how are you damaged?
Well, the project was delayed a year and a half.
Was it delayed? Or I thought the subs kept working. So we can read from this record that the subs sat on their hands because they weren't getting paid?
No, We can read from the record that the project was a year and a half late because the
But-
dates are there.
But a lot of public contracts are a year and a half late. Most of them are.
I agree. There was liquidated damages provisions in this contract that provided that if it was late, there'd be compensation. The Stimulus Act money actually had to be spent within 2 years.
But
It was-
again, nothing to do with the breach isn't, I mean, unless we can find that it may very well have contributed to the delay. I just can't tell. I haven't read the record. But right now, we have a breach without that proof. We have a breach, and the only obvious damage is that you paid money to them that they weren't entitled to because they hadn't paid the subs.
The issue is not so much whether the result that occurred here, because they didn't have the insurance to proceed in equity, results in these kinds of situations. That doesn't make the rule unfair any more than the odd results of the application of the Fourth Amendment or any number of other constitutional provisions.
But
make
you
it
get the
unfair.
benefit from it. Maybe I get the benefit because I'm a citizen of Massachusetts, but the person who's harmed isn't rewarded. The owner is rewarded. And that seems a little strange.
To
doesn't
some
it?
extent, what the rule says is, contractor, you're not going to be able to argue what Justice Kafka just argued in a court of equity if you intentionally breach. The provision in my hypothetical that said, employ my brother for a year because that's why I want the work done, if that's breached intentionally, the contractor doesn't get to argue about how important it really was to employ my brother. The contractor doesn't get to do that because they intentionally breach. The rule is flexible in its application. I don't think I ever understood the meaning of the phrase, the exception that proves the rule, until this case. There aren't many cases out there like this where a bad result has happened because of this rule. In fact, good results have happened. Even in the certified power case, which my brother mentioned, which we discuss at footnote 31, I think on page 28 of our brief, the trial judge in that case, yes, there was false certifications, but the trial judge also found that the general contractor had been squeezing the subcontractor, deliberately not paying them. There were specific findings of bad faith. That's the kind of extenuating circumstance that's built into the rule. I don't know what the result would be if no money was paid until the end of the project and then we found out something like this. Can the rule be applied to that extent? I don't know. If you use the insurance analogy, then they didn't buy an insurance policy. They acted in bad faith. There are some sets of rules. In some ways, the best civil rules are the ones that are generally not violated. They're complied with, both because they comport with people's common sense understanding of what they should be doing. They don't require perfection. And rather than imposing a specific penalty, they simply say, if you abide by this rule, we'll give you a right. And the right is you can recover in quantum meruit.
But why should the rule involving construction contracts be different from the rule in any other contract?
It isn't, at least not in any clear way. The cases that were cited by my colleague.
Well, I mean, the argument is that it's different that in every other category of contracts, there must be a material breach to release the party, and you're saying here that something less than a material breach is sufficient because of the Sipley and Andre versus McGuire case.
Those were construction cases, but the rule's been applied in other contexts. In the government case, it was applied in an employment context. When you get away from services contracts, contracts to supply services at arm's length, and you get into fiduciary partnership situations like MEIN, or pure commission sales contract situations, which have always been treated fairly uniquely, the rule doesn't seem to be discussed. But the rule that is prevalent in all of the major states across the country, New York, California, Florida, Texas, all the large states follow the same rule, and most of the smaller ones. It's a concept that seems to be applied particularly in building contracts, and part of the reason for that is, I suppose, that you can simply and always make the argument, gee, I built what you wanted. I built what you wanted, give me my money. And yet, in public contracts, as Justice Budd was pointing out, there are these provisions it's hard to enforce otherwise. Justice Kafka, I read the decision in Acme on the Court of Appeals, where you were on the panel. I believe the provision was you're supposed to follow instructions to do extra work, and the contractor didn't do that. How do you enforce those provisions from a practical standpoint? The way in which the law does it is it incentivizes the contractors by saying, if you do your best, if you act in good faith, you have protection against not being able to complete your contract. Before my time is up, I want to say a word about...
Can I push one more point on that? So,
Of course.
these contracts, just what you say, they're 1,000 pages, they're 800 subs. So any sub, does one intentional misdeed, right? The general's responsible for that, right?
Yes, but that doesn't...
You got one plumbing contractor or one, AC subcontractor, one who's, and just he does something a little shady. Not the first time in construction law that's ever happened, right? So some giant building, UMass garage, something like that, you got no right to get paid?
That doesn't trigger the rule, in
Why
my
not?
view.
Why not?
Well, for example, on this project, there were a half a dozen permit waiver memos that were falsified. It's in the record. Ms. Krantz testified. I would never have made this motion based on that. A low-level person did it.
Not. You're entitled.
For the simple reason, number one, it's not the act of the corporation. These are corporations. It has to be the act of the corporation, not a low-level person. And in this case, obviously it was. It was the vice president.
But does the Cardozo rule limit it to acts of corporation? It's just any intentional misconduct on a construction contract, right?
Well, no, it's with respect, it's
No,
it's
you got-
any
these are
intentional
questions.
misconduct of that party. Whenever you have a corporation, it seems to me that it has to be the act of the corporation. You can't bar a corporation's right to recover. We expected on this summary judgment motion to get affidavits from the senior officials saying, look, we're sorry this happened. It's not corporate policy. We don't want to do it. That the subcontractor that the Justice Kafka, you just opined, maybe makes a mistake. Doesn't reflect corporate policy. We're sorry about it. They didn't say any of that.
So
Why?
the rule is limited to corporate level misbehavior?
No, certainly if the contractor was an individual, it would be his or her. My point is that there's a de minimis exception, and it's a flexibly applied equitable rule. And the reason we're troubled by our own cross-appeal...
I guess, where's the flexibility? If it's flexible, I think it sounds great, but it seems like it's rigid and absolute.
Actually, no. In Peabody and Sullivan, this court has more frequently found that recovery is permissible than not by invoking the de minimis exception. It's a practical, equitable rule.
To talk about practical and equitable, the amicus brief from the Association of Builders and Contractors, they said, when we talk about practical, well, this isn't how it works in the real world. Simply it's not followed in the real world, and these type of windfalls create uncertainty in the area of construction, and therefore we should change the rule.
Well, we know from reading the DiMatteo case that that's not true. DiMatteo's joint venture on the Big Dig specifically argued the rule against the secured creditor of a subcontractor, and the secured creditor said you should certify this to the SJC. That's a case cited in the amicus brief by the contractor associations. It's ironic. They say it was a forfeiture, but if you look at the case, the secured creditor came in and said, we don't know the value of the work that Cyclone, the subcontractor, provided.
Big picture point from the Association of Builders and Contractors about this rule from 1906 does not reflect how business is done.
But the rule may have originated in 1906, but the most recent application was 1998. And the amicus brief of the contractors is stating, as we pointed out in our brief, the rule as they would like it to be. Who wouldn't? Who wouldn't want to not have to do your best? Who wouldn't want to not have to comply with what you didn't want to comply with? But the only way to enforce the provisions to have a do-your-best good faith rule is to have this kind of rule. The beauty of this rule, it's like an elegant mathematical equation. It seems complicated, but it's really not. It just says a contract means all the promises in it. But if you can't do them all, as long as you try, you can recover here. It's an equitable doctrine, which is why As far as our cross-appeal goes, we waive it if the first decision is affirmed. I'm troubled. I'm very reluctant to criticize any aspect of the Superior Court's handling of the case. I argue against myself, I realize, on the cross-appeal. But from our standpoint, it was a federally funded project. We made the best judgment we could in making a second motion. I don't think the Superior Court was too happy with me in coming back on it. Perhaps I was wrong. I did the best I could. But it does no violence to the rule for the court to affirm across the board here, and it's in the interest of MassTech to have the case over. They're not in business to pursue fraud claims. That's an issue for another day. The first rule, though, is important. I'm responsible for having made the motion that I did. I heard the arguments about forfeiture. I didn't accept it. They got 85% of their contract price. They made their own bed, and
Would it have mattered if you had been slower in payments and had only paid them 65%?
Yeah, I think it would have been an extenuating circumstance if we were slow paying them, and that was part of the reason for their not paying their subcontractors. One of the features of this case procedurally is they didn't want any 56F discovery. They specifically said, we don't want it. They had made an argument, and you can't say that and then come back and say, well, you should have waited. I mean, that's not fair. I mean, the Superior Court looked at an awful lot of material. That's why I'm loath to criticize any aspect of the court's handling of it. It was a lot of material, and I'm responsible for submitting it. But the testimony and the evidence, and I'll wrap up, was so clear here. There were, Jennifer Krantz, the contracts manager, I thought perhaps, gee, are the questions so clever that she's admitting false? And then I realized she wanted to tell us. Why? Because she'd been telling people for 2 years, this is wrong. And that's in the transcript. Hence, we ask the court to simply affirm the final judgment below across the board. Thank you.
All right, thank you.